Thank you very much for joining us tonight. This is the monthly gathering of the Commoner Law Group's Free Traveler Monthly Confab. And every month, every first Tuesday, we meet. And oftentimes it's just us folks talking about various things related to the God-given natural right to travel from place to place in our automobiles and whatever conveyance that we choose without the permission of the government. There is a future in which, God willing, we will restore the republic and we will have common law and we will have natural law amongst men and women in this land. And yet we do find ourselves in a different kind of situation today, and we're going to learn a lot about it tonight. So thanks for coming. It's going to be a very exciting and compelling conversation. We are lucky to have a featured speaker tonight who has prepared a great presentation for you all. We're going to spend the first hour of our 2 hours together just focusing on traffic, specifically the citations that most everyone here probably in your lifetime, you've gotten one, some moving violation. Probably 99% of you in those situations, there was no victim, there was no harm done, but you did break some sort of statutory rule. Well, we're going to unveil tonight how the whole system works, how it is that the justice system that starts with that roadside pullover, those red and blue lights behind you, starts there, but it goes all the way through to the courts, and how we're going to find out really how it all holds together. It is a scheme. It is a very concerted scheme with financial incentives for those who participate in terms of the judges in particular and the whole court system. But I do want to thank you for coming, because you're going to want to stick around to the end, because we will also expand the conversation. As so often we do here on these Tuesday nights, we start talking about the right to travel, free travel, and then we recognize that the same scheme that's used to take our right to travel and convert it to a privilege for which you have to pay extends well beyond travel into other matters. And we're lucky that Todd has a very extensive knowledge of how this all works. And so in the second hour, he's thankfully agreed to share with us what he knows about other schemes, in particular the one that's of great interest to many people, which is income tax. So fasten your seatbelts. It's a lot of information. Get your notes out. And if you stay all the way to the end, Todd has some white papers as well that he'll post in the chat, and you'll be able to download in real time. Again, this is the Commoner Law Group's Free Traveler Monthly Confab. If you want to learn more about Commoner Law Group and our educational offerings, you can go to commonerlaw.com. I do particularly want to recommend that you all check out the Great American Law series, the Republic that was established 250 years ago that has slipped away. We want to restore it. And in this course, you learn exactly, as Americans, true Americans, what you need to know in order to help bring forth and restore the constitutional republic based on natural law, where we men and women are individually sovereign and collectively as a people sovereigns of this land. So let me introduce Todd Duell, wonderful fellow. He's got the receipts, so to speak. He's got the experience, a remarkable experience and background. And so I'm going to go ahead and turn it over to Todd right now. And starting with, an introduction of yourself, Todd, just let people know who you are. They need to know the deep experience that you have, including your relationship with your father, who's a judge, and your legal education as well.
All right. Glad that everybody's here, and I'm grateful for Clint to invite me for everybody. And I wanted to let everybody know that, yes, I have a background. My original background was actually as an executive in the pharmaceutical industry, senior scientist engineer in Southern California. And then I switched over to law, mostly as a result of my dad, like you mentioned. He was a judge and law school professor. So these were normal topics of conversation in our house, because my aunt and uncle owned banks, and my dad was the general counsel for the bank, and Federal Reserve officer was their next door neighbor. So we had different conversations at our dinner table while I was growing up, and things of that nature. So understanding the commercial side of how the system works and bonding and underwriting is kind of like my specialty. On the side, mostly what I do is I help people with their complex irrevocable trust to protect their assets, and do banking and taxation differently, which we'll talk about in the second hour. But this first hour, we're going to actually talk about how to deal with traffic tickets, because I get people's traffic tickets smashed all the time in court. If you do it properly, you can do very minimal process with the courts to break them, and to basically you can win every single time, even on appeal if necessary. And I'll teach you guys how to do that tonight, and the basic questions that you have to ask. Yes, common law does exist. Common law, just so you know, is basically private contracts between people. That's what kind of like what equity is private contracts, private law. But common law does exist, and I work very closely with the IRS Criminal Investigation Division. I don't work for them, I work with them. And so there are white hats and there are black hats within the IRS as well, and all the other agencies. And so I work with the white hats that basically want to smash the accounting from all of our aggravated identity theft, tax evasion, embezzlement, and securities fraud that's happening against us, which we'll talk about, like what the traffic ticket is tonight. Is it's a security. Where the common law exists with the IRS, it's Internal Revenue Code Manual 9.1.3. That's the criminal statutory provisions and the common law, right? This is what our trustees are doing to us. Okay, they're basically embezzling from us and committing aggravated identity theft and filling out tax documents and lodging them with the IRS to extend our credit to fund these bonds that they're creating in our name, which of course that's securities fraud and identity theft and a whole slew of other issues with the Securities and Exchange Commission that they don't want to admit that they're doing. And yes, when they get caught and you know how to catch them, they do turn tyrannical because they are looking at career-ending events and they are looking at federal prison time if they get caught doing what they're doing. And so that's where we go after them with very specific documentation, very specific IRS codes that they're violating, to the point where we can, if necessary, take these guys into U.S. tax court under criminal charges under the common law. So this is where we're getting our remedy against them, is in U.S. tax court, because that's what they're doing. Everything in this country is an excise tax. We're all being taxed to death. And when you understand that, you start using the tax codes against them because they're there for our benefit. And the IRS has to follow them because they are IRS policy for accounting, right? There's no case law for accounting. It's GAAP, so that generally accepted accounting principles, and GAS, generally accepted accounting principles for securities, right? They have to produce the accounting. If they don't, it turns into a willful felony for them under 7206. So we'll talk about those things today. So the traffic tickets is an interesting scenario. And if we just start from the scratch, yes, the ticket that you get from a police officer, they know nothing about the securities. Those low-level deputies that are just deputies, maybe you might run into a corporal somewhere. Maybe on rare occasion, you might run into a sergeant if he's training a deputy, but you're never going to run into a lieutenant or a captain out doing traffic patrol. That's not going to happen. The captain and some of the higher up lieutenants that are looking for captain positions, they will know about the securities on the tickets, and they're deadly afraid if you start bringing that information up. And believe me, I've been surrounded by dozens of deputies, dozens of U.S. Marshals, and when I pull out the accounting and the statutes and the codes for the accounting and let them know they're operating under color of law, they run. They literally run for me because they know better, because they know I'm going after their surety bond and the crimes that they're committing very, very quickly. I've literally had to yell at many of them to come back and give me their name and badge number so I can file a tort claim against them personally for what they're doing, conspiring to aid and abet aggravated identity theft, tax evasion, embezzlement, securities fraud, right, under color of law. You start saying these words at them, they run very quickly. They know they're engaged in career-ending events when somebody starts actually going after the accounting and they don't understand. And the crux of all of this is understanding your basic core right. Anytime you're dealing with an administrative agency, remember this is all an administrative process. We have Article 1 administrative courts. We do not have Article 3 constitutional courts. You can invoke an Article 3 constitutional court in a federal court, but not a state court. State courts don't have jurisdiction to invoke an Article 3 court. It's like, I've never heard of one doing it. Federal courts, you have to push them really hard. There's a couple Supreme Court cases that can invoke it. But before we even go down that part, we don't argue law, we don't argue venue, we don't argue jurisdiction with these courts per se. Jurisdiction a little bit by the way we approach the court, but we don't argue with them. We go straight after the accounting on them, which they can't ignore, and they get very, very nervous very quickly. Like I said, it's career-ending events for the judge, the clerk of the court, and the prosecutors. So your core right that every single person needs to understand. Okay, my dad was adamant about this. Under the Fifth Amendment, shut up again, and shut up some more. Invoke your Fifth Amendment right to remain silent. Do not talk to these people. They are doing an administrative process to gather information they do not have, right? And they will use it against you. They are there to protect the public corporations, not private citizens. So this is understanding the difference between public and private. We are private citizens, they are public, they are statutory. That's public law. Okay, public law is statutory law. Right? We are private citizens. We deal with private contracts between private citizens. Right? We're not trying to contract in any way, shape, or form with these people, but when you are driving or traveling, whatever you want to call it, okay, whatever argument you want to make, you have to remember these are administrative courts. They only follow the penal codes. They only follow the revised statutes, codes, ordinances. They only follow that. They are not mandated to follow any case law. Okay, they don't have to accept case law. And they're not going to, especially when you start banging constitutional right. You have to remember you're going to be found in contempt of court if you bang constitutional rights in an administrative court. If you start arguing case law for liberty interest to travel by right, you're going to have a really hard time winning that. I know a few people that have won over the years, but it's very spotty. It's very few people that will win that argument. They'll have to push it really, really hard. If you wanted to push it super hard, sometimes what I recommend for people is if you can get the judge to avoid a bench trial, right? And so you move it from the traffic court, you move it into state court, you go to a bench trial, and then you start informing the jury of their right to jury nullification, right? That's how you beat them, and that's how you smash the traffic laws, is through jury nullification. Because once a jury nullifies the penal code, right, now that can no longer be used in the entire state. It's gone, and they can never bring it back. So they took jury nullification out of the courts in like the 1950s, and they were instructed by the Supreme Court to the clerks of the court to no longer inform the jury of their right to jury nullification. The assumption is that the jury knows that as the sovereign people, the sovereignty of the people, you have the right to nullify any statute, code, or law or ordinance that you don't think is appropriate for our society. Because remember, the legislature just put this in place. They never asked us to vote on it. So the people can take it down to a jury and during jury nullification. So that may be an entirely different class that we might want to do on jury nullification. Right now, it's just like, oh my God, I got a jury summons. What do I do? Should I like fight it and say I'm not a US citizen and like get out of it? I'm just like, well, that's up to you. You can actually get out of it if you want by saying you're not a US citizen. They'll actually kick you out of the jury pool. But for me, what I would prefer to do is go in there stealth. And I've done this twice, actually. I've gone in there stealth and basically said, you know, everything possible to be proactive for the court. Yeah, I'm doing my civic duty. I think it's my responsibility to serve on a jury trial. I'd be more than happy to participate and be unbiased. So I've actually had a couple jury pools dismissed because I went in there and I asked a couple basic questions to the prosecutor, because in the jury actually has the right to inspect all evidence. And so it's pretty easy when you're in the jury pool. You send a note to the judge. I have a couple of questions to ask. The first is, what's the Sixth Amendment nature of the accusation that the prosecutor is bringing against the named defendant? And I need to see the IRS 1099-A, the QSIP, the bid performance and payment bond. I believe you committed aggravated identity theft, accounting fraud, concealment, securities fraud, tax evasion, and embezzlement. I need to inspect the accounting records that the clerk of the court has and the district attorney's office. And I need to see the bond. I think you forged the defendant's name. Right? That immediately gets the jury pool completely kicked out of court. Everybody that's waiting to possibly even become part of the jury pool gets them kicked out. And then all of a sudden the cat's out of the bag and the defendant is going to want to know, you know, how did you get the entire jury pool dismissed? Right? What did you say to the judge to dismiss everything? Right? So this is at the crux of every single traffic case, criminal court case, civil case. It doesn't matter. They're administrative courts. They're all running with a bonding system called a bid performance and payment bond. And we actually have access to the securities and accounting for that stuff to squash all of these cases, which is why they get very, very scared. And so understanding that crux of how the court works at a basic process with the IRS, because it is a court of the IRS, then we just go after the accounting and there's no arguing law within the court, because once the accounting's done, they don't have jurisdiction. They don't have what's called in res jurisdiction over the securities, and they don't have in rem jurisdiction over you. But I am going to kind of explain a little bit with the traffic ticket how they got jurisdiction over you. And I'm going to go right to the root cause. Your driver's license has a security behind it, which has a CUSIP number attached to it. We can pull them, we can lien them, and that's how the courts get in rem jurisdiction over you, because they have a CUSIP or a security on your driver's license. Now, this doesn't excuse you from trying to drive on or travel on the roads without a driver's license, without plates, without insurance, without registration, because you already know what they're going to do to you. Okay, they're going to pull your car over, they're going to break your window, they're going to haul you out, they're going to beat you, they're going to throw you in jail. It's not worth the hassle with the incompetent police officers or highway patrol or law enforcement officers to argue with them on the side of the road. They are incompetent. They do not know the Sixth Amendment nature of the accusation that they're bringing against you. They believe that it is a common law criminal charge. They do not understand statutory jurisdiction. They barely understand color of law and what that means. They believe that they have a right to do what they're doing because the legislature has written a statute or a code or an ordinance for them to enforce. That's what they believe. They believe that they have the authority to do any of those things to you. If they do anything that's not within that statutory jurisdiction, now they're operating under color of law. But the reality is they are operating under color of law at all times because they are doing aggravated identity theft. Because when you're in public, you're operating your public fiction entity, your corporate entity, right? You're still a private citizen, you're just in public. And you have to understand that when you're on the roads, what they consider this is a private trespass, right? And under the trespassing laws, what it says is you are welcome to drive on our streets. You are welcome to drive on our roads or travel, whatever you want to call it. You're welcome to do that. You are free to do that. Please follow the driving laws to the best of your ability. If you don't, we can, tax you, excise tax and fine you. But we want you, if you want to trespass on our property, and believe me, we the people think we own the land, we don't, right? Our debt has been hypothecated and rehypothecated to the foreign creditors under the bankruptcy. We don't own the land. Foreign creditors own it because they buy our bonds. They own it. We don't own it. We're the creditors, they're the debtors. And this is part of the problem with the argument of understanding what sovereignty is in terms of constitutional sovereignty versus debtor-creditor relationship with the government. So in our current bankrupt system, you never really want to talk about the sovereignty of the people in an administrative court because there is no sovereignty in that court. It's all about debtor-creditor relationship and fixing the accounting to make it appear as if you are the creditor, they are the debtor, because they took the instruments from you, they took the money from you, that makes them the debtor. But they also did it in a fraudulent scheme, and this is what we catch them in. So please, so you don't, I have many clients that come to me that have been the tar beaten out of them, and then we have to beat them in court, which is hard to do, but then they're basically terrorized in the courtroom. Please have a driver's license, please have plates, please have insurance, please have proof of registration. So they have no excuse to attack you, right? Be kind, be courteous to the police officers because we can beat them in the courtroom every single time without fail. Okay. And so the general understanding with the courtroom being administrative, the way they got in res and in rem jurisdiction against you, and believe me, this is actually taught when William Tetley was alive. He was a professor at Tulane Law University. He actually taught arrest and attachment and related maritime procedures under civil and common law. So he basically exposed to the law students in advanced classes how they do the arrest and attachment of the bid, performance, and payment bond, how they gave themselves the authority to do it, right? Because the administrative courts under statutory jurisdiction are what are called colorable vice admiralty. So the case always starts in admiralty because the bond that they open. Bonds are in admiralty, right? This is why sometimes I joke, I say we're driving on their tar rivers, right? They're admiralty tar rivers. And of course, the attorneys get all upset. They're talking about rivers and ships and maritime law. And it's just like, go back to law school, people, the Glide and the Corsair. It's well known that all governments operate under admiralty maritime jurisdiction because of the bonding and underwriting system. This is how the entire government system operates. It always has for hundreds of years. This isn't a new concept, by far not even new. But they've really hidden it from the bar attorneys, so they don't really know what they're doing in a blended law firm jurisdiction inside the court. So courts are always law, equity, admiralty, maritime. They're blended civil law courts, okay? It starts in colorable vice admiralty because of the bid performance and payment bond that the court opened. And then it basically comes down to an agreement in the court. Okay, I agree to, spend 3 days in jail and, 50 hours and clean up on the highway. I'll pay this fine. That's the agreement. That's the contract that you sign with the court to pay fines and do penalties and go to traffic school and do all these things. And then that is enforced in equity, right? That is the process of how the courts work. Bonds in admiralty, the agreement in law, and then enforcement in private equity against you. That is a private law, private contract against you. You now must pay and perform. But the irony is when you understand that they started with a fraudulent security under aggravated identity theft, now the game changes. Now you can assert your position in the trust that was created. Now you can assert the position that you have as a creditor in the system, and they're the debtor and they're obligated to do the accounting. So it starts with understanding your core rights. They must tell you the Sixth Amendment nature of the accusation. But if you look at the U.S. Constitution under the Sixth Amendment, it says the state must tell you, right? You must be informed of the nature and the cause of the accusation. I don't care, speeding, fine. There's no injured party, right? There's no common law crime. There's no affidavit of a criminal complaint from an injured party or a non-state employee as a witness. Okay. So you see that right there? Guarantees, right? Guarantees that they must tell you the Sixth Amendment nature of the accusation. Okay? So that is critical. That is always, always, always the very first question that you ask them. They're mandated to answer it by law. There's a very famous Supreme Court case for pro per or pro se litigants. I'm actually pro per because I'm a holder in due course. If you're not a holder in due course, you're pro se. And so what you ask them is that question under Ferretta versus California, which is your pro per right to self-representation. It basically says if they don't tell you the nature of the accusation, you can do an appeal after the case is over and you lose. You can do an appeal to the appellate court. And it's a major reversible error that is vacated on appeal. So no matter what on a court case, if you ask that question and they will never ever answer it because it destroys the premise of the Article I Administrative Court as being an excise tax, they will never answer. You will win 100% of the time, right? 100% guaranteed. So the next question you always want to ask them, okay, so if you're bringing this under a criminal statute, because they listed as a criminal statute, not a civil statute, because they blended civil and criminal and traffic courts. I don't know how they ever got away with doing nonsense like that. You ask them under Article 3, Section 2 of the United States Constitution, it only lists 4 possible law form jurisdictions: law, equity, admiralty, maritime. 2 of which are the only possible criminal law forms that you can charge under. One is going to be common law. The other one is going to be colorable vice admiralty. We know it's not common law because you guys don't recognize common law under Erie Railroad versus Tompkins, okay? Because you guys got rid of common law in the states and the courts in 1938, and you squashed our common law rights. And so the only other possible criminal statute is colorable vice admiralty, which means I need to see the contract, I need to see the 1099-A from the clerk of the court, the QSIP, and the bid performance and payment bond. I'm declaring aggravated identity theft of my tax records and a fraudulent bid performance and payment bond. You must turn that over. That is the contract. I never signed it. You forged my signature. It was not notarized. This is identity theft, tax evasion, embezzlement, securities fraud, you name it. You guys have broken so many federal laws that I'm going to move this case to U.S. Federal Tax Court because this is the only place that we can actually get accounting remedy out of you people, right? And this is going to be a criminal charge against you because under 26 U.S.C. 7201 and 7206 and 676, you guys have concealed the accounting and the bonds with the intent to defraud me. And so this is now a criminal action that I can bring against the district attorney, the prosecutor, the judge, and the clerk of the court. You had no authority to write those tax records and those bonds for me and conceal this information from me. This is an IRS court. It's an administrative court. I'm going to use IRS rules against you. And if you think that you're going to supersede or override the IRS, I'll see you in U.S. tax court. All right, you will be a named defendant, and you will be in handcuffs in an orange jumpsuit very quickly. All right, so you can imagine when I go into court and I say things like that, they get very scared very quickly, because one of the things that I do is and I'll show you, or I'll tell you the forms that you fill out for all of this. I won't show the actual forms to you. But when you already do the accounting, you already act like a creditor in the courtroom, they get very, very scared very, very fast because they know they're caught. They know that you canceled and discharged the securities through the IRS. They know they don't have in res or in rem jurisdiction over you, and everything is smashed. And you walk in basically to look at the judge and say, I'm here to revoke and revest the trust that you created, that fraudulent trust. And I'm demanding that you guys do the accounting on your books. I've already done it on my side. You better do the accounting on your side, because I'm turning you into the IRS for tax evasion. All right. So they want us to act like creditors in the courtroom, but they trick you into acting like a debtor, right? That's their job, is to trick you into acting like a debtor and taking responsibility. And like the Bible says, right? Are we supposed to be the surety for other people? Why are we being the surety and the guarantor for our debtor legal fiction? We're violating biblical principles by walking into that courtroom and acting like a surety when we're not. We're a creditor. We should never act as a surety for that thing. The surety is actually the depository trust clearing company, right, in New York. Well, they're in New Jersey now, but New York. Okay. So if I walk you through, like, my typical pleading to the court for a tax ticket, that I take my clients through, one of the things that we have to address in the courtroom right away is a case called Trinzi versus Pagliaro. We just throw this in here. I'm not arguing case law with them. Basically, it says an attorney for the plaintiff cannot admit evidence into the court. He is either an attorney or a witness. If you've ever been in a traffic case, is the prosecutor acting as both an attorney and a witness at the same time? Yeah. Okay, so you can vacate this case because the attorney will never, ever bring in any witnesses against you. And even if they do, it's a sheriff or highway patrol or whoever it may be. But the whole time, they haven't submitted any evidence to the court. There's no facts in the court for the accounting. There's no facts for the court in the accounting. They have nowhere to go. This is a motion order to dismiss for failure to state a claim upon which relief can be granted. That's talking about accounting. If you won't give me the accounting, I'm motioning, ordering to dismiss this case. I see no accounting evidence in the courtroom. None. No certified gap and gas accounting. I can't help you if you won't produce the accounting for me, right? But as soon as you ask them for the accounting, right, the cat's out of the bag, isn't it? The cat's out of the bag. They know what you're after. You're after the accounting and the bonds, okay? So the other one that we also address in the court is 26 USC 676. So remember, anytime you have a ticket, that is a trust instrument because there's somebody else managing it on your behalf. They're a fiduciary. You're the beneficiary, grantor, bailer, owner of that ticket, right? And the court is acting as your fiduciary, your trustee. The judge is actually a banker, right? And they're operating a commercial court for a private commercial entity for profit. And just so you guys know, one of my jobs is I actually train judges on the commercial bonding and underwriting and the commercial paper that they're writing and their liability if they don't handle the accounting. And so when I train them on this, a lot of judges' eyes get like big as dinner plates because they had no idea. They took the accounting out of the courts quite a few years ago now because people were beating the courts on the accounting because the courts had the TTNL terminals and the Bloomberg terminals in the judges' chambers. They took them away because the judges were screwing up the accounting at the IRS and the Treasury Department and our minor account. Okay, so they were screwing up the accounting, so they took it away from them. And so now they have no idea what's going on with the accounting. And then they can also claim plausible deniability. We've never heard of a CUSIP before. We've never heard of a 1099-A. Accounting, what are you talking about? Right? They play dumb with you. They gaslight you. All right. But the reality is in U.S. tax court, there's no gaslighting the accounting because we blocked everything up through the IRS with the proper forms. Okay. So the interesting thing with 26 USC 676, that's power to revoke. What that statute is talking about is basically when you revoke the trust, your ticket, when you revoke it, there's no more ticket. Okay, that contract is revoked, it's gone. Now, anytime you've revoked some type of commercial instrument, the only thing that's left is accounting. So when you revest it, the IRS says you have the right to revoke and revest. Then the IRS says that you are the grantor, bailer, owner, and beneficiary of that entire instrument. So when you revest, that means liquidate. So now they have to liquidate that instrument. So a lot of these court tickets are $40,000 or $50,000. Okay, here in Hawaii, each line item on a ticket, it's an individual bond. There's an individual CUSIP for each one. And so here in Hawaii, we know that the Yakuza mob own the courts. And so they're basically stripping the Treasury Department, taking the money back to Japan for their criminal activity, right? So you got to be really careful here in Hawaii because you're playing with the Yakuza, right? And they think it's their money, right? So they're doing war reparations is what they're doing. Yeah. So be careful. In California, like all of Southern California is owned by the Russian mob. So they own the courts in Southern California from like Ventura County down. Okay, so be very, very careful with the Russian mob too. They don't like their money being taken either. Okay, so think about, so you are the grantor, you granted the ticket because you signed it. You're the bailer. Bailer means you transfer the securities to them, although they never told you they were doing that. So that's what bailer means in the Uniform Commercial Code. Beneficiary obviously means that, you know, it's a trust. You're the beneficiary of all the proceeds, rents, profits, interest. And then, of course, owner means that that is yours. The IRS says you own all of that instrument. Everything that's in it, everything that's purchased with it belongs to you. So if it's me, I'm going with what the IRS says. Right? I'm not arguing with the IRS. That's what they say that I am. And as soon as I revoke and revest that trust and give the proper notice to the court, which is in a fiduciary position to manage that trust, they're in a lot of trouble. Okay, very, very quickly. I'll also come through with things that I section in my pleading to the court says facts not in dispute. So I'm going to agree with the court on several facts. Okay, one of them, of course, is, you know, in our family, we don't own anything, but we control everything. So our vehicles are all in complex irrevocable trusts. So we actually have the UCC lien on the vehicles. We own the manufacturer's certificate of origin. We have all the bonds for the vehicles locked up. We have the driver's license bond locked up with UCCs. So we're liening everything and splitting legal and equitable title with the trust. So the state no longer has legal title ownership over your vehicle. That is one of the ways that they actually get in rem jurisdiction over you and in res jurisdiction over your property is you handed over your manufacturer's certificate of origin for the brand new vehicle. If you bought it new, or whoever bought it and you bought it used, they handed it over to the state so you could register and get plates, right? Without the MCO, the state's not going to issue plates for your vehicle. That's why it takes about 30 to 60 days to get plates for your car. So they're taking legal title ownership in the trust that you created without your knowledge and understanding of what you were doing to get plates on your car so you could travel on the highway and not be harassed by the law enforcement officers. You created a trust that created a bond. We have to pull that bond. We have to pull the MCO. We have to lien it, make it our property, right? And so then what we're doing is we're making the DMV the debtor in the process, and we're the creditor. Right? We're correcting the standing in the system of who's debtor, who's creditor, who's trustee, who's beneficiary. We're taking everything away from them. We're saying, hey, we'll transfer this to you, bailer or bailee, fine, because we don't want to be harassed. But when time comes and we need our property back, I'm taking it from you. Right? You don't take property from me, I take it from you. And I've already taken it from you and I've corrected the commercial registry. So that's a really interesting issue in the court that really throws them for a loop of who owns the vehicle, who has legal title ownership over the vehicle. It's not you, state. The trust owns it. And this is a complex irrevocable trust, which we'll talk about in the second hour. Like I said, splits legal and equitable ownership of the vehicle into the trust. The beneficiaries cannot be tapped by any creditors, meaning the state, neither can the trustee. The only way the trust can be tapped is it has a contract with the state somewhere to pay or perform. The only place the trust would have a contract to pay or perform would be to pay for the registration. That's it. Okay. There's no other performance for the trust to make other than paying the registration, because that's the only bill they ever send. Okay. Okay. So again, the other thing is that in my particular case, I have a different status with the government, and I'll actually kind of show you. I got this out for everybody today. And I know we kind of talked about we talked about earlier today about not being a state national. That's fine if you want to do that. That does offer some basic level protection. You really have to know how to argue that. I don't know if everybody can see this. Okay. This is what it takes to have a contract with the federal Secretary of State as an internationally protected person, stamped and sealed. Okay. But stamped and sealed by the United States Secretary of State. So they're in a lot of trouble when they try to pull me over and I'm an internationally protected person because it has specific provisions to protect me for using the highways, right? And the streets. They cannot come after me. It's actually it's $100 million fine to them if they come after me and they threaten or harass me as an internationally protected person just using the highways to drive or travel, whatever you want to call it. Okay? So they get very, very scared when they see that very quickly because they know they're not supposed to argue with me because I have UCCs on that because there's a bond behind that too. So I have a right to revoke and revest that with the federal government. I have a right to revoke and revest the bond on the plate. I have a right to revoke and revest my driver's license. They've all been put on notice that I can revoke and revest these trusts anytime I see fit because I'm the trustee. They're not trustees. Okay. I'm the secured party, trustee, holder in due course. I'm all the good things in the commercial system. And believe me, it takes a long time to get to the point where you can do that and understand it. Okay. Another thing, the third item that we're not disputing in the court, the Sixth Amendment nature of the accusation. For example, here in Hawaii, we have Hawaii revised statute that basically says that on the ticket, they have to state the nature of the accusation. Have you ever seen a ticket state the excise tax as the commercial nature of the accusation, or did they write down criminal? Right? And so they failed even under their own statutory law, as well as the Sixth Amendment that they're, trying to argue. So that in and of itself, just in Hawaii alone, we could defeat any case just on that because the ticket doesn't state the nature of the accusation, which they're mandated to do by the legislature. Right. So in some cases, some states you can kind of get by with that one, but that one wins as well. Okay. Let's see. So one of the other ones that we do is we let the state know that we understand you're operating under the Commerce Clause, Article 1, Section 8, Clause 3 of the United States Constitution and United States versus Lopez. We understand that you're regulating all activity, whether we're operating in commerce or not. Because it's all an excise tax. All commerce is taxed, correct? All commerce is taxed. Somebody's paying taxes when you sell something, right? And so what we're trying to let them know is, hey, we understand you have the right to regulate commerce, and we understand that bond that you're selling is a commercial activity. Now the question is who's the principal, owner, bailer, beneficiary, secured party? Who are all these positions within this trust that you've created? Seems to me I'm all the good ones, and the only position you guys are is the debtor, right? You guys are the bailee and the debtor. That's the only thing you can possibly be, because guess what? My name and my numbers are on that thing. That means I own it. And I want to know how you created it without my knowledge or consent. That's aggravated identity theft. That's 18 U.S.C. 1028A. If you wanted to know, that's what the IRS charges aggravated identity theft of your tax records on, okay? And so you can let them know that, okay, whatever, revised statute that you're trying to charge us under, fine. We know under Article 3, Section 2, again, there's only two possible law form jurisdictions, common law and colorable vice admiralty. We give them a copy of what the Constitution says. And so we let them know that, it's pretty much, it's called black letter law, that they're charging in colorable vice admiralty jurisdiction by the arrest and attachment of your bonds. And I let them know where I know that I understand that they got the jurisdiction from. And I use basically the training documents from Professor Tetley from Tulane Law University to let them know that I'm aware of how they think that they generated the right to do this, and that this is an ancient principle under the law merchant, right? Bonding and underwriting has been going on for thousands of years. It has not changed. You can get out of paying for something by posting a bond. there's a very famous case from 1948. It's called Black Diamond versus Robert Stewart and Sons, which talks about the 4 different law firm jurisdictions, and that the person was charged with a crime, and that he posted bond, and then it switched under admiralty rules from Rule 51 to Rule 52 and 53, which basically says that as soon as you post bond, you're now set free. Now you can argue in the court, who are the creditors, how much do we owe them? Under Rule 53, the court's supposed to adjudicate the claims. In statutory terms for the courts, that's 28 USC 2041 to deposit your bond in the court, right? 2045 is to adjudicate the claims, pay your creditors. Title 28 is the judiciary code for adjudication of claims. Do you think your judge wants to do your accounting for you and the clerk of the court? The clerk of the court will accept your bonds all day long. They know what they are. They will accept them. They will deposit them. But then the judge will refuse to process them. So we actually file a criminal complaint against the judge for embezzlement of U.S. securities if he doesn't order the clerk to process them. Because technically the security is actually an administrative process. It's not a judicial process. So the judge is not supposed to strike the bonds or deny the bonds in any way, shape, or form. The judge is actually supposed to process them, do the accounting, let the judge know that it's been done, and then handle it from there. But the courts have bastardized the process and they're incompetent at this point with what they're actually supposed to do. Okay. So that's another little thing that we can use against them. We can also, because they won't put the accounting onto the record until after you've entered a plea, and then the prosecutor will state like the crime that you're being charged of, and then the judge wants you to say, yeah, I accept the plea and I accept the contract, blah, blah, blah. I'm going to pay these penalties. I'm going to go to this traffic school, blah, blah, blah. And then what does the judge do at the end? He gives you the accounting. He tells you how much you're going to pay. Well, I'm just stating right up front. And the nature of federal rules of civil procedure rule 12b-6, they failed to state a claim upon which relief will be granted. They failed to state the remedy. They're concealing the 1099-A QSIP bid performance and payment bond in violation of 26 USC 7201 and 7206, which is a felony. And they failed to produce any evidence of the certified gap and gas accounting records. Judge, I want you to certify that accounting. No? Oh, then I think you need to dismiss this case because that accounting is not certified, and I'm not accepting your accounting as true and complete and accurate. I think we're missing a whole bunch of accounting called the private side accounting that you have in chambers and with your Chris custodian in Washington, D.C. Right? So they've hidden stuff all over the place against you guys, okay? And so the accounting fiscal office, the clerk of the court, they don't have the accounting anymore. The district attorney doesn't have the accounting anymore. But the process generally is the prosecutor opens the complaint. So they get the ticket from the sheriff or the police officer, they get the ticket. The prosecutor opens the complaint with the clerk of the court through their terminals, right? And so they don't have to pay to create the bond, okay, because they have a government code that they use to pay for the cost to create the bond. And so the clerk of the court takes the open complaint. The clerk of the court, according to the IRS, and you can read this in publication 1099A and C, page 3 and page 4, the clerk of the court's responsibility administratively is to open the securities with a 1099A to acquire your secured property for the ticket, right, to back the bond. Okay, so that's the clerk of the court's job, to create the bid performance and payment bond and the 1099A and assign a QSIP to it so it can be traded and sold. Most of the bonds are put on the international bond market within about 3 days. So the commercial paper is gone very, very quickly because they don't want anybody to have it in their possession because that's proof of a crime. If you're a holder of a forged instrument and you're trying to sell it, you're actually committing some serious securities fraud under SEC 10b-5, 18 U.S.C. 472 and 475. Yes, I do have colleagues in the securities industry that do sell the court bonds. And I ask them every now and then, why do you sell those? You know what you're doing. They're just like, well, number one, I'd be fired if I didn't. Number two, I need to feed my family. And number three, everybody in the world buys these bonds because they're highly sought after because the government always pays. The government never defaults on these prisoner bonds. Okay, kind of scary, right? Like everybody's involved in feeding off of this thing, and they basically make the excuse that I need to feed my family. All right, that's not a legitimate excuse to covet your neighbor's property, is it? No, not an excuse, not ever. Okay. Now, one of the other things that we also let them know is, we're not going to argue with you over trying to arrest me, because under Trezevant versus City of Tampa, it's $25,000 for every 23 minutes that you have me in custody, right? And if you really want to look at the ticket, I'm actually out on recognizance right now because I signed it, so you wouldn't beat the tar out of me, right? So I'm on recognizance. So technically, I'm under custodial arrest the entire time. I'm just on recognizance right now. So I think from the day this ticket was open until the day you canceled and discharged this case, I think I'm charging you $25,000 for every 23 minutes. And I've got case law that says you have to pay, right? That's federal case, and that's what's used when you do settlements with under the 9 USC 1 through 16 with the US arbitrators. All right, this is what well-known, well-established law. Okay, so I'm not arguing the law, am I? That's what the law says for this particular issue when you keep people in detainment illegally with forged securities. Right? Think about that one for a minute. How quickly that's going to rack up, considering they take months to resolve these cases. You're looking very quickly at a 7 or 8 figure tort claim coming back at them. But now you understand when we start calculating the torts under 18 USC 3571, which is the civil claim for the torts at $250,000 for felony and $1.5 million a day, you understand why they're going to fight you in the courtroom now, right? They don't have that kind of money. Their budget doesn't afford them to pay damages like that, even though the reality is when you get a check back from Treasury, and I have checks back from Treasury, the check comes back from you. You're paying yourself. They don't have any money. It comes back from your minor account. Okay, so they're not paying. You're paying yourself. You are insuring them for the crimes that they're committing. And this is why we should be outraged in this society that we're paying for them to commit crimes against us. This should never, ever happen.
We have this one specific example of a dismissed case, and I was just wondering if there's anything in this document here that you think is noteworthy. Help.
Yeah, so let's take a look at this. So this is one of my clients that has a federal tort claim now, because they arrested him for like 1 day. Played dumb with him, and then he came to me. I smashed his securities, and they immediately dismissed the case, and then he immediately turned around and filed a federal tort claim against the prosecutor, the DA, the judge, and the clerk of the court, and now they're freaking out. And so you can see the traffic crime plea. Notice they didn't check anything. He didn't plea anything. He continued to resist them the entire time. I'm not entering a plea until you tell me the Sixth Amendment nature of the accusation. I'm not entering a plea until you put the bid performance and payment bond in front of me and the QSIP and the 1099A. Until you do these things, I'm not entering a plea, period. And you can't plea for me. That's practicing law from the bench, and that's illegal. You can't give me legal advice, all right? So at the bottom, you can see that they dismissed the case with prejudice. Well, he got it dismissed with prejudice, which is fantastic because now he has an absolute tort against them. They do have to pay damages, right? The issue is they didn't check the box discharged. So what does that tell me in a commercial realm? When they didn't discharge it, they didn't discharge and cancel the security. It's still open and running. So until they resolve this issue with him and the accounting, that bond is making like 400% compounded per year. They make tremendous amounts of profit off of this, and that bond is now his because that's his property that they dismissed. All right. So they did refund him his bail. So they had to pay like $500 bail or something like that. So they did refund his bail. Okay, so you can see when you start asking just the basic questions, he only asked the Sixth Amendment nature of the accusation. He only asked for the 1099A QSIP bid performance and payment bond before he came to me. That he asked for it, they wouldn't give it to him. He refused to enter a plea. He just resisted. He resisted for almost a year before the judge started saying, we're just going to take you to trial. He's just like, you can't take me to trial. There's no plea entered, and you can't enter one for me. Right. And then he finally got to me through one of my colleagues, and we came in and smashed the accounting, and they immediately dismissed the case. So when you go after the accounting, it's a totally different beast. And let me see if I'll show you what a GSA bond looks like, because I do write these for clients when necessary. This is what a bid bond looks like. Okay, so this is from the GSA. So They're basically making you the principal, they're making you the surety, not really, the depository trust clearing company is the surety. But what you want to look at is where it says the penal sum, right? Penal sum of bond, right? This is where the clerk of the court and the judge are supposed to get together and do the accounting and put in however much that bond is worth. They're supposed to put that number in here, right? They're supposed to put in, I mean, I fill these out because I have like the court number and the QSIP and, you know, I already have everything. So they're supposed to fill it out and then send this information to GSA for processing at the Bureau of Fiscal Services at the Treasury. The clerk of the court knows they have to do this. It's Title 15, Title 41, Title 48, but the judge of the court refuses to allow them to do that. And so that becomes a problem as far as I'm concerned, because now they're embezzling US securities. And so this is one of those things that's a document that we use against them with the IRS when we go after them for embezzlement of securities, because now when we do that, the court is engaged in embezzlement and tax evasion and securities fraud, right? So these are now criminal charges against them to do that, okay?
Wow, wonderful.
So,
Yeah,
yeah,
thank you so much.
yeah, so let me talk about some of the other stuff that goes in with it as well, okay? And so, I mean, we're going over a lot of stuff, but when we talk about what they're doing with the bond, they won't give you the accounting, they won't give you the securities. These are things we're not arguing with them. We know they're doing it. And so under 26 USC 7206, if everybody reads that, it's going to say fraudulent bonds, permits, and entries, right? So the code says simulates or falsely or fraudulently executes or signs any bond. Did they sign your name to that bond? Oh yeah, they did. In fact, they typed your name in. You didn't even wedding sign it, and they didn't notarize it, right? So any document required by the provisions of the internal revenue laws or any other regulation or procures the same to be falsely or fraudulently executed. That thing's, you didn't sign it and you didn't execute it. You didn't notarize it. That's fraud and fraudulent, right? And then the next one is removal or concealment with intent to defraud. Okay, the IRS says removes deposits or conceals or is concerned in removing, depositing, or concealing any goods or commodities for or in respect whereof any tax is or shall be imposed. Yeah, there's taxes due on that bond. Somebody has to pay 27.5%, and that's the court, right? That's the minimum tax under 26 USC 108 section IB4, 27.5%. Okay. And so they're talking about with the intent to evade or defeat the assessment or collection of any tax imposed by this title, shall be guilty of a felony, and upon conviction thereof, fined no more than $100,000 as an individual, $500,000 in the case of a corporation. So we got the judge, 100,000, clerk, 100,000, prosecutor, 100,000, DA, 100,000, the court, corporation. So we're at 900,000. We got the district attorney's office. That's 1.4 million. Then we take into the sheriff's department, that's $1.9 million just right out the gate on one violation of own. They're almost at $2 million. You just start adding up the numbers, right? So we're going to ask for these as penalties against the court, right? Because that's what the statute states is the crime that's committed and the statutory penalty to pay. Because remember, these penalty dollar amounts are so high because they understand that the check is going to come from the Treasury Department. It's going to come from your minor account. Okay, that's where it's going to come from. So what kind of documentation do we have to deal with the courts? Okay, we've got the Attorney's Handbook of Accounting, Auditing, and Financial Reporting. The IRS gave that to the courts last year and said, you will do the accounting or we will come for you. All right, so these are the instructions to the judges, the clerks of the courts, and the attorneys. You will do the accounting. If you don't know how, it basically says if you don't know how, you will hire a CPA, IRS enrolled agent, or a special master. You will do the accounting. We are not doing the accounting for you anymore because you're screwing up our system so badly and causing such a backlog. Because I'll tell you right now, when you do the accounting complaints with the IRS, the wait time for an initial response, 640 days. That's how much fraud is going on with people's general ledgers, with the bonds and every other fraudulent thing that the government's running behind our names and numbers. Okay, so failure to keep the accounting, as far as the IRS is concerned, it's a violation of Sarbanes-Oxley, which is public law, statutory law. They can't say no. Okay, And it's codified at 15 USC 7202. So if they don't follow it, now they're in that says it will be treated as a violation of the Securities and Exchange Act. Going after them for securities fraud. You must keep the accounting. You must do the accounting. If you claim you don't have the accounting, you're in violation of Sarbox and the Securities and Exchange Commission because you are selling commercial securities. Somebody has the accounting. You better figure out how to find it because we're going to the IRS. Right? So there's also the ability to petition for a warrant for the records. 26 USC 7302. Remember, I'm not arguing case law. IRS says property used in violation of internal revenue laws. It shall be unlawful to have or possess any property intended for use in violating the provisions of the internal revenue laws. You have accounting. You're doing tax evasion. You're violating the internal revenue laws. What are you doing? IRS says I can audit you. I'm here to audit you. Right? They don't want anybody looking at their books because now every single case comes because you're in a criminal court. Guess what happens in a criminal court when you take out one case? Absolutely, just one case gets taken out like this. Every single case opened by the district attorney while they're in their office now can be overturned. Every single one. Doesn't matter whether it's a traffic case, doesn't matter if it's a criminal case, or like I'll say a real, criminal case, where somebody's been arrested and sitting in jail. Every single case can be overturned for this issue alone. Do you think they're going to fight you? Oh yeah, they are. They're going to play dumb really, really fast because they can't afford to have every case for however long the DA's been in office overturned. Think about that for a minute. Everybody gets let go that's currently in custody, like waiting trial, or anybody that's in custody because they're sentenced, every case gets overturned very quickly. Think about the impact, okay? So what we do to the court, okay, the first thing we do when we go in there is we let them know, okay, we filed our motion. We're going to let them know that you don't consent to the state of whatever or any other agency to use your social security number, right, with the intent to defraud me, right? So we let them know that we're not going to authorize them to do that. We've got a bunch of forms that we've already filled out. One is the Social Security form SSA-89, which basically says I never consented to you to use my Social Security number to open those securities or access my securities accounts. Okay, that one's bad for them. Form 14157, return preparer complaint. We're saying clerk of the court and district attorney, you prepared some type of tax records for me. You didn't give me my records and I never authorized you to do it. So I'm also going to file the 14157A, which is a tax return preparer fraud or misconduct affidavit. Uh-oh. Aggravated identity theft coming for you, right? You were never authorized to do this. I didn't get my copies. You refused to give them to me. You're playing dumb. Oh, and then court, by the way, form 13909, tax exempt organization complaint referral. I revoked and revested the securities. You're embezzling and doing tax evasion. You think that you're a willful, non-lawful or willful, non-taxpayer organization. When you revoke and revest and they embezzle, they are guilty of tax evasion. They are not exempt when they embezzle trust funds. Nobody's exempt from that. I don't care what your EIN number is with the IRS. When you embezzle money that's not due to you, that's tax evasion. Right? This is now you see how we start to nail these people for tax evasion, and they get really scared really fast because they are looking at prison time on the federal side. Okay. We also let them know that we don't consent to a trial. Okay, we're not going to do a trial. We're just here for the accounting. We don't consent to go to jail or prison on behalf of the named defendant, which is an estate. Right? We don't consent to that. Believe me, I've got plenty of people out of jail that were sitting in jail, and I said, just get your plea agreement from the prosecutor. Tell your public defender they can't sign it for you. On the back of it, just write, I accept your presentment for a set-off settlement, discharge, closure of all accounts. I don't consent to go to prison on behalf of the named defendant estate. Right? And the judge literally throws a fit in the courtroom but has to let him go because they got what they wanted. They got to keep the securities, but they couldn't keep the body. Right? And I've got lots of people out of, in jail custody for just that basic of a thing to do because it's a trust agreement. Even you being in jail, by the way, is a trust, right? You can just revoke and revest the trust, and now the sheriff is on the hook for basically aggravated identity theft. So yeah, that's a fun one to throw at them. They get really nervous really fast, and usually the lieutenants and or the captain will come and have a little visit with you if you're in custody about what you think you just did to them, right? They get really nervous very fast. We do want to, so if you guys understand your biblical scriptures, Matthew 5:25 through 27, which basically states, agree with your adversary while you're on the way to the court before they hand you over to the judge, who hands you over to the bailiff, who hands you over to the jailer, and you will not get out of prison until you've paid every last penny. Right. So we do accept their presentment because the ticket is a presentment to pay the excise taxes. We do accept it, but we're going to do a specific negative averment against it, which basically says we're revoking or revesting the securities. We need you to produce the accounting records, the bid performance and payment bond, and we're basically only here to do set off settlement, discharge, balance the accounts to zero, and dismiss the case. And everybody go home. The accounting's been done. So they have a really hard time when you've accepted their presentment for them to do anything stupid to you, because now it's on them. You threw the commercial liability back at them to perform the accounting. Okay. Some of the other stuff that we do to them is I do put a bid performance and payment bond in the court. They're not going to accept it. But again, what I tell people is it's there as a trap to get them in U.S. tax court for aggravated identity theft and securities fraud. We do place a UCC lien on the 1099-A and the QSIP and the bid performance and payment bond. So we liened it in the commercial realm, so it's our property. Now they have to produce the accounting records because we've liened it. We show them that we have a lien on our driver's license bond because we have the QSIP. We've got a bunch of other forms that we fill out with the IRS and lodge with the IRS and give a copy to the court. One is the 14039 identity theft affidavit. Another one's the 843 claim for refund and request of abatement. 3949A information referral. The one that kicks everything off is actually the 211 application for award or original complaint. That's actually the criminal complaint lodged against the court for all of these documents that we're filing and what we do and what we file with the IRS. Okay. 4506T is the request for transcript of tax return. That's how you get your 1099-A, B, and C back from the court or from the IRS, so you can do your accounting properly, because the court's plain stupid and they won't give it to you. We talked about this before, the 13909 tax exempt organization complaint. That's a complaint against the DA's office and the judge and the sheriff's department for not paying taxes on the securities. 14157, the return preparer complaint. 14157A, tax return fraud or misconduct affidavit. SSA 89 from Social Security, blocking them from using your Social Security. We'll file a corrected 1099-A against the court. So we'll show the court is acquiring the securities and the money, because they always file it as you are the borrower and they're the lender. That's fraud. You're the lender, they're the borrower. They always fill it out backwards. So that's 7201 violation. That's another felony with the IRS for preparing tax forms incorrectly. The 1099-C cancels and discharges the securities. So that one screws them, because now there's no res jurisdiction because you canceled and discharged the securities. Now they're selling fraudulent bonds. We'll file an FTC complaint. That's the Federal Trade Commission. That's for aggravated identity theft. They're mandated to investigate aggravated identity theft charges and claims using your tax records. Yeah, and then if they really want to get dumb, we'll do the Securities and Exchange form, the TCR tip complaint or referral. That's a criminal complaint to the Securities and Exchange Commission because you revoked and revested the trust, and they're embezzling, doing tax evasion. You canceled it with the IRS, and the court didn't cancel the securities with the SEC. The reason why they don't is if they cancel the security, they have to liquidate the entire pool, which could be millions of dollars. So somebody asked a question here in the chat, approximately how much in US dollars have you actually received from all of these cases that you've been part of, and exactly how are you paid? So my last client, the court tried to send him a check for $41,000. They refused to give him the accounting, but they sent him a check for $41,000, thinking that that was going to be what's called a novation. Okay, novation basically means court in satisfaction. It means that the court's getting off the hook. They're paying you and they're absolved of all liability because they paid you, right? All criminal liability for them goes away. The problem is what my client said is you harassed me so much. I don't believe that this is the correct accounting. $41,000 even is not the correct accounting. I demanded that you produce the 1099-A, B, and C, the bid performance and payment bond, and the certified accounting. It said you're not going to provide it. I will see you in U.S. tax court. So they are currently in U.S. tax court. They rejected the $41,000 payment. I think in like 2 weeks, because U.S. tax court takes 60 days to unseal the complaint. And so I think in like 2 weeks or something like that, the prosecutor in U.S. tax court has to produce the accounting or dismiss the case. If they dismiss the case, they're going to the Court of Federal Claims. And then the special master in the Court of Federal Claims in Washington will have to handle the accounting. They're currently talking about, I spoke to them today. They were talking with the U.S. attorney who wants to dismiss the case. And remember, the U.S. attorney is on their side. That's the prosecutor. They're saying that they don't understand the accounting claim. You're just like, dude, you're the U.S. attorney from the tax division for the IRS, and you're telling me you don't understand the accounting? You can't get me the A, B, and C. So what I said is send them a really nice letter. Say, if you dismiss the case, I'm pulling the CUSIP, because they already pulled the CUSIP for the U.S. tax court. So the U.S. tax court already pulled a bid performance and payment bond against my client. So we pulled the CUSIP for that. And I said, send them a sample 211 with the CUSIP and say, if you dismiss this case, I'm naming you as a co-conspirator. And I'll see you in Court of Federal Claims. Right? You guys can't just keep opening bonds and denying remedy and denying relief. Right? You guys have to do the accounting, and you people are the accountants. There is nobody else to go to. Right? So you can see how kind of out of control the courts have gotten, to the point that even some people within the U.S. tax court are also corrupt and are protecting the administrative judges and the prosecutors, because those are their bar members, right? Those are their colleagues. Why would they put their colleagues in prison when they're doing what they're told, right? And I don't like that excuse. We're just doing what we're told. Well, you know, like our parents said, will you jump off a bridge if somebody told you, right? So I hate that excuse of we're just doing what we're told. We're following the policies and procedures. This is one of the reasons why we noticed Doge and a couple of, and the IRS Criminal Investigation Division Chief, Guy Fico, when we're doing this process, to let him know, you better get your people in line, because you don't have any choice but to follow your statutes and codes and policies. You can't supersede IRS code, right? Because you have no authority to change Congress's authority to write the taxing codes. Right, that's Congress's authority. You can't supersede it. Okay, so let's see here. So the time to perform for them under bond estoppel or American jurisprudence is technically 30 days. So we let them know where the American jurisprudence comes into play. So if they want to argue, you know, the American jurisprudence, good luck. We're basically just showing them how bad they are and how corrupt they are. But we do put a ledger in there. And so the ledger can become pretty high, pretty fast. As you can imagine, the court bond is 40 to 50,000 in general. And now you've got, if you start collapsing any of your securities, like your driver's license bond, that could be a lot. If you're collapsing any other securities that you have, like your birth certificate, could be a lot. Because you can bring that into the court. If you have your CUSIP and you got your liens on it, you can revoke and revest your birth certificate. Be really careful doing that, because that's actually an unlimited account, and they don't like it when you know you can do that. That's infinity. And so they freak out when you start revoking and revesting that thing. Trezevant versus City of Tampa obviously is $25,000 for every 23 minutes. Aggravated identity theft is 250,000, securities fraud 250,000, 18 U.S.C. 472, outing counterfeit obligations or securities, the penalty is 250,000. 18 U.S.C. 475, imitating obligations or securities, 250,000. 18 U.S.C. 676, embezzlement through the IRS is 250,000. 18 U.S.C. 371, 7201, attempt to evade or defeat tax, that's 250,000. 26 U.S.C. 7206, fraud, false statements, and concealment, again, IRS, 250,000. Unauthorized use of tax records for pecuniary gain, there's a whole bunch of statutes for that, 250,000. Civil rights, deprivation of rights, civil action for deprivation of rights, 42 U.S.C. 1983, which is what they're operating under, color of law, 250,000. 18 U.S.C. 242 and 245, again, 250,000 apiece. If you wanted to, if you're throwing GSA bonds in the court and they don't process them, 15 USC 1, trust and restraint of trade, illegal penalty, and 15 USC 2, monopolizing trade of felony penalty. Those are 100 million each. So you can very quickly see that you can throw a ledger at these people to the point where you can bankrupt the entire state very quickly, right? Because that's the type of crimes that they're committing, and they don't understand what they're doing in the commercial realm. They think they have unlimited ability to tap the minor account of the Treasury Department. Okay, so you just have to start making the claims with the IRS documentation. If you have that CUSIP in hand, that's a pretty powerful tool, because you're basically going to let them know that they're going to do the accounting, or you're coming after them through the IRS, and you have standing to sue because you've been injured by them. They're claiming you injured them by whatever, $1,000 for a speeding ticket, but you're saying you injured me by $200 million. I'll do a set off on the accounting on that all day long, and you can give me a check back. Or even at the basic, if they say the $1,000 penalty for your driving speeding ticket, but the bond is worth $41,000, okay, fine. Set off the $1,000 from the 41,000, give me a check back for 40. I'll take it. Right. So sometimes I tell my clients, you have to figure out what is the number that you'll accept. Will you be okay with the 40,000? Okay. Most people are just like, yeah, that's totally fine, because then they'll leave me alone forever after that, because they know that I understand what to do to them. I know the forms to fill out. I know how to act like a creditor. And then there's other people that get harassed, windows broken, arrested. They're just like, screw these people. I want it all. Right. And I'm just like, okay, then that means you need to be willing to go to the U.S. Court of U.S. Tax Court. You need to be one to go there next. It's not that hard. And then you have to be willing to go to the U.S. Court of Federal Claims. So you're looking at probably about a year out before you can get any type of remedy. So do I have checks back for myself? Yeah, they come from the Treasury Department, right? And it comes from my minor account. So I do have checks back for myself. So the court never cuts you a check, the Treasury Department does. So even if the state court settles with you, the U.S. Treasury cuts you a check, right? And they say, we don't have anything to do with the federal government. Well, how come I'm getting a check back from the Treasury Department? You guys are lying to me. You're fiscal agents, 12 USC 266. You're a bank, right? You're part of the Federal Reserve Bank. You're part of the entire banking system as a fiscal agent, right? You're a private commercial bank, right? And then sometimes I'll laugh at them and I'll be like, well, how come you have Federal Reserve notes behind the counter if you're not a fiscal agent? What are those doing back there, right? Somehow you're doing banking, right? If you're doing banking, you're a fiscal agent under Title 31, 5123. Somewhere along in those statutes, you are just considered a bank. Right? These courts are banks, people. They're banks. They're operated by the IRS. Don't argue case law in there. Don't argue statutes and codes. Accept the presentment that they gave to you. Do the accounting. Act like a creditor. Ask them a couple of questions. The basic ones are, what's the Sixth Amendment nature of the accusation? What law form jurisdiction are you charging this under? Because it can only be law or colorable vice admiralty. You know it's not law. It can only be admiralty. That means you have to produce the 1099-A CUSIP bid performance and payment bond, because that's the alleged contract that you claim that I'm violating, because somehow my signature's on that thing. So I didn't sign it. This is aggravated identity theft, right? I never notarized that security. This is securities fraud. Right. So you can see how they freak out very quickly, that you know the underpinnings of what they're actually doing has nothing to do with driving, has nothing to do with traveling, has everything to do with the bond that they created and the excise tax that's due on the bond. That's how they're getting jurisdiction over you. That's why they're mad at you, because the taxes aren't being paid on the securities. But it's their job to pay it, because they kept the securities, they embezzled it, they have to pay the taxes. Right? They don't want you to know that, because they want to keep it all, right? And then they want to throw you in jail and fine you, right? And do all kinds of dumb stuff to you. So you can imagine what I've told you here. This is super high-end stuff, right? And the very few people, except those of us that work with the IRS, actually know that you can do this to them, and that they're breaking so many administrative laws with the IRS that they irritate the IRS all day long, because they fill out the forms wrong all the time, right? So good luck on your hunting for this information. I can get CUSIPs for people. I can, help you with your administrative process if necessary. If you need to smash a court ticket, you have to have a little bit of oomph in you to want to go into court and just say a few things. So I actually did I put in the court appearance. So this is for everybody's benefit here, the court appearance, how to appear in court, right? How do you appear specially and not generally? Because when you appear specially and not generally, now you're no longer in a statutory jurisdiction, you're in equity, and you're only there for the accounting. You don't argue anything else. You admit to everything else except the accounting, right? Everything else, I don't care about the cause. I need the nature, I need the accounting. They're stuck, right? They're backed into a corner they literally can't get out of. And as soon as you've already filed all this stuff with the IRS and the criminal complaint is open against them, they get really scared really fast because it's a career-ending event if they don't do the accounting. And the irony, when they took the accounting out of the courts, they can no longer do it. And now they are guilty of basically accounting fraud and concealment, right? And then they'll play dumb. We've never heard of this before. I'm sorry, that's fraud and false statements and concealment. Okay. So that's a traffic ticket in a nutshell. If you wanted to know how it really, really rolls out in the courtroom and you really, really want to beat them, because guess what? It takes you beat them one time, they'll leave you alone after that because they know you're going to do the same thing to them again, right? So this document that I showed you guys, the International Protected Persons, I actually have a do not detain on my law enforcement terminals. They know when they pull me over not to issue me any citations. Okay, so that does take a little while. It takes 6 months to a year once you get that status for it to percolate through the law enforcement terminals. But they can see the state national, they can see the international protected person because the United States Secretary of State, there's a code that they have to actually transmit this to all the law enforcement agencies. So it's a helpful tool. It's not the silver bullet for you to have that, but all of these things are just tools to put them into a weave that they cannot get out from underneath.
All right.
That was a mouthful, Clint.
Oh my gosh. Well, let me be the first to thank you, and I know that others will do the same, but thank you for just the generosity of your time and your wisdom to be shared with us tonight. We'll be doing the Q&A right now, so folks, if you go ahead and put your questions in the Q&A. Clearly, this is a very large subject matter, and you can make an entire study of it. That's why the Commoner Law Group and Todd, we are together working out something that will be of service to you. I'm going to start, if you don't mind, with the first question, which is super fundamental, and has been so much said about it, but I still sometimes get confused with the difference between private and public, because again, we are dealing with a house of mirrors here. So, maybe according to natural law, what is private and public, and then what is private and public in
Okay,
the world, where the real world we live in.
Okay, so let me define public for everybody. Okay, so this is from Ballantyne's Law Dictionary, third edition. Anybody can get a electronic copy of this for free. It says the vast multitude, which includes the ignorant, the unthinking, and the credulous, who in making purchases do not stop to analyze but are governed by appearance and general impressions. Right? J.W. Collins Company versus F.M. Paste Company, 14 Federal 2nd 614. So this is one of the things that was kind of struck home in our family, the difference between public versus private. So public is public law, statutory law, statutes, codes, regulations, ordinances. Those are public law. Those are corporate policy. They apply to your legal fiction corporate entity that they created for you. They don't apply to you per se as a living man. They try to fool you into thinking that you are one and the same as the debtor, that the living man is the same as the corporate fiction. It's their job to trick you basically into folding and agreeing that you are one and the same. And so understand that when you're contracting with the government, you are contracting in public law, right? And their policies and procedures. The government operates under two separate jurisdictions. The legislature is required to hopefully create laws that are constitutional. They don't always do so, which is why they get challenged in court and ends up in the Supreme Court and overturned. And then the legislature has to rewrite it. That is our standard due process for the legislature. The other is the government operates outside of the Constitution under the Contract Clause and the Commerce Clause. That's how they get out from underneath the Constitution under the administrative laws. And that's actually a very famous case. It's the United States versus Bank of Osborne, where they talk about how the government gets out from underneath the Constitution and its constraints by you contracting with these dumb agencies that think that they can write policies that supersede the law, which is what the Chevron case was about in the Supreme Court this last year, where they're not supposed to be writing policies that supersede what Congress's authority has granted them. Okay, so we're sort of trying to correct this, but the courts are resisting the Chevron case. The courts are resisting the executive order because they don't like the Supreme Court. They don't think they have to follow under the supremacy clause. They don't like Donald Trump, especially in any of our blue states, do not like Donald Trump. And so they are basically doing everything in their power not to comply with anything that he's ordered them to do, which is an interesting dilemma because the United States is a bankrupt debtor corporation, and he's the president and CEO of the corporation, right? Executive officer. And they're saying that we don't have to do what you tell us to do, even though we're one of your corporate entities, right? And so there's case law that basically says that the states are municipal subsidiaries of the United States corporation. And so the president's municipal subsidiaries are saying, turning a thumb up to them saying, we don't have to do what you tell us to do. And he's just like, fine, I'll cut your funding then, right? Government shutdown, right? Do what I say, or I will shut your funding off, right? How powerful is that in terms of political power? With no money, they have no way to pay their bills. Nobody's going to contract with them. Their employees aren't going to show up to work if they're not being paid, right? So there is the ability of the checks and balances to, force the municipal subsidiaries, the states and the agencies to do as they're told. And so unfortunately, we shouldn't have to go to that extent. I think our public trustees should understand their role is to support the people. That's what they were hired to do. They're not doing it. They're supporting private corporate interests and insiders and things of that nature, and they've gotten out of control. And I think this group understands that probably better than most people in the United States that don't really truly understand beneficiary trustee relationship, debtor creditor relationship. Now that I've explained you guys debtor creditor relationship, that should be a big eye opener for you that you're one of the most powerful positions as the creditor. And there's the debtor. Debtors don't tell creditors what to do. Debtors do set off on the accounting, period. Right? And they don't want to admit that they're a debtor. They think they're the creditor, and they don't even understand the United States monetary system. You hold a debt, you're the debtor. You have the instrument in your hands, you're the debtor. The other person's a creditor. They gave it to you somehow. But remember, you didn't give these instruments to them. They took them from you. They signed your name to these instruments and didn't tell you what they were doing. They didn't disclose it. When you ask them for it, under administrative law, 5 U.S.C. 551, 552, 552A, you demand your accounting, they say they don't have to turn it over. That's fraud and false statements and concealment. That's a willful felony. And even under administrative law, they have 30 days to comply, or you can charge them in the civil court. If they default in a civil court, it becomes criminal. So you do have remedy against them, but you have to push them really, really hard. And so that's why we just push them through the IRS. That's the fastest way to get at them. So the nice thing is we have access to the QSIPs and the securities, so we can get the accounting reasonably well and prove criminal intent. Right? That's the whole thing, is when they do willful gross accounting misconduct. Now under Internal Revenue Manual 9.1.3, the IRS says it's a willful criminal act. So there's a definition for it. When you ask for it, they say they don't have to give it. It is now willful. Right? Willful is a huge legal term that basically means this is now criminal. Okay? That's why you have to go after them. Unfortunately, these people are criminals. They say they won't even identify who has the accounting, right? They claim they don't have it. Or if you hit the person that does have it, they say we don't have to give it to you without a court order. Well, yeah, you do, because my name's on that account. That's my account. That account doesn't belong to the county or to the state or to whatever agency that thinks it's there. That's not your account. That's my account. I want my records, right? So this is what they're doing. And this is why the government was up in arms this whole last year, for many months at the beginning of the year saying, Donald Trump was out there saying they're stealing from you, all of them, right? They are thieves, right? That's why everybody was getting audited, right? Even the IRS was being audited. So my colleagues that work at the IRS were flipped out because the Doge was in there auditing the IRS. So when everyone is saying the IRS is going to be taken out, no, they're not going to be taken out. They're going to be forced to actually follow their own codes. The laws may change for corporations. The laws are going to change in terms of how we do banking in the digital world. Things of that nature will change, but overall, the IRS is going to stay. We need an auditor. Somebody has to do the accounting. But we're hoping that there's like major upgrades that will happen that will make the accounting easier for everybody and more transparent. Right. So right now the transparency is in the Stone Ages, to say the least. I think they're still running AS400 systems at the IRS from like the 1980s. I swear to God, they got green screen terminals. I'm just like, no way, that's not possible. Those things can't be running anymore. How are the chips on those servers not fried by now? Yeah, if any of you are a little bit older, you know what I'm talking about with the AS400. The
I
big
was a
giant box.
technology consultant in those days, and I used to help people move off of those systems way back. Yes. So we got some more questions. I have got one here. We'll start with. It says, "What was the case law you mentioned regards to the unlawful detention damages, as in the
Oh,
charges?"
that's Treasury versus City of Tampa. Okay, so that's the one that said it's not unreasonable to charge $25,000 for every 23 minutes for unlawful detainment. So as soon as you've done the accounting and you cancel the securities, there's no bond, right? As soon as you put a GSA bond in the court, you posted bond. If you pay for a bail bond, you posted bond. And so they should be holding you in custody when you're only there to do the accounting in administrative court, because that federal court knew in that particular case that the money that was going to come back on the tort claim came from the minor account at the Treasury Department. So they're basically saying that's an unlimited credit account. Because the reality of what happens when you get that check from the U.S. Treasury Department coming back to you, what they've done is they filed a 1099-A against the judgment that's in the court for the settlement. So they've acquired that and they turned it into a security and sold it. And then they're basically giving you a check from your own account back. Right? So they're making money hand over fist. No matter what, they're making money. Whether you get a judgment or not, they're making more money. They're selling it as a security. Right? Because there's no money in the minor account. It's a book entry account. It's basically infinity. There's no numbers in there, but they can extract from it at will. Right? So this is how a bond is created at the U.S. Treasury Department. When Congress says we have to ask the Treasury to write a bond for this $1 trillion, bill that we're writing. Okay, the credit comes from the people because they're always talking about how are the people going to pay this back? How are we going to justify the people paying this $1 trillion bond back? Oh, well, where did the credit come from to begin with? Oh, our minor account, it came from us. It already came from us. Why should we pay for this? I don't want to pay for that stuff. I don't agree with any of that. You guys aren't even giving me the option of not basically protesting that bill you're signing into law. We don't even have a chance to say no to that thing. Why should I have to pay for that thing? I don't want that. I don't use any of those services or products that you're purchasing, right? There should be some mechanism for us to stop what they're doing because and then of course they're saying that, well, you elected us, so you have to do what we say.
Yeah.
Right? Too bad, so sad. Well, it takes forever to, get rid of you guys out of office. So that's why I like the jury nullification route. That's a fun little one to throw at them. If you want to buy a really good trust book, it would be The Art of Passing the Buck. You can buy that at Amazon. Just get volume 1. You don't need volume 2, which is like $500. Volume 1 for $50 is enough.
Again, amazing information. One of the more sensational things it seems you covered was the mobs behind the scenes. So there's a question about who owns Northern California. I live here too, so I guess I'm interested.
I don't know. I think the last time I knew the Hells Angels own Northern California. Yeah, my dad actually represented Sonny Garcia, who was he was the head Hells Angel in the 80s. He's family law, though not on the criminal side. He did traffic tickets and stuff for him every now and then, but he mostly did his firm handled their family law stuff, the divorces and things like that.
We've got Todd Duell here again. We're so grateful to have, and he's obviously a gentleman, a scholar, and an athlete. Somebody does have a question about how long did it take you to learn all of this stuff?
I grew up in a house having to deal with this, so I would say my entire life of education and stuff. And you do have to stay on top of things as things change and things like that. The bid performance and payment bond has been around since, well, technically the mid to late 80s under Ronald Reagan's administration. He's the one that created this nonsense because the courts were broke. That's when they privatized all the prisons. It wasn't until the 90s that a gentleman named Gene Keating and his two brothers that were federal judges in Los Angeles County actually kind of figured out what was going on with the bid performance and payment bonds. And they unraveled all the accounting and the securities in the court through the Uniform Commercial Code. Gene Keating went to Hastings in California. He was an expert in the Uniform Commercial Code and bonding and underwriting securities. And again, his brothers were federal judges, and so they dealt with the commercial side on the federal courts. But of course, they had to study as well because they didn't understand, even at that level, the complexity of what was going on. So they blew it out of the water, and they were never ever beat. Now, did they try to kill them? Yes, many times. Yes. You have to be careful when you know what I know. It's very dangerous to know what I know, but I'm not afraid of them because they leave me alone because they know I'll wreck them in courtroom.
Yeah, thank you for mentioning that. All right, so if you have questions, please go ahead and type them in the chat for everyone to see, and we'll go ahead and take your questions as they are relevant and they come through here. So there's this idea of reinvesting the trust.
Revesting.
Yeah, revesting the trust, and how does that relate to sovereignty?
Okay, so when we talk about revesting, so we do, if the IRS says revoke and revest, so do these two things in conjunction with each other. Revoke means to terminate the trust contract, so that's revoking, so there's no longer a contract. You revoked it because your names is the only ones on it. So that bid performance and payment bond that I showed you, you saw, if you looked at the signature line, you're the only one there. You're the principal and the surety. Oh, how did I become the principal and the surety? Oh, that means I own both sides of the ledger. If I'm the principal and the surety, I'm the debtor and the creditor. I have both sides of the ledger. Okay. And so we want to revoke that. So there's no longer a contract. Now we're down to accounting. Revest means liquidate. Right. So if there's money in that account, liquidate it, give the court however much they think I owe them, and then cut me a check for the rest. Remember, that's why I give that example. A real example, tickets are like 40 or 50,000. If your ticket's only 1,000, but they already took 50,000 from you, now they owe you $49,000 check. Right? That's why my client got a $41,000 check from the court, but he refused it because he knew that it was worth more than that because there was penalties associated with the dismissal and the discharge. Right? So that is the key. So look at IRS 26 USC 676. So that's what the IRS says. And I think I agree with them. Don't you agree with them?
Mm-hmm. Yes,
yeah.
Indeed.
I 100% agree with the IRS.
Oh.
I like the IRS. Right? Most of you hate the IRS.
Show.
Yeah, but the IRS has some stuff that's on our side too.
All right, so yeah, I had this question just generally speaking without addressing any specific case, but maybe you're already in the middle of a case, or what about the question of retroactively? You know, can I go back and get to?
Yes, we typically don't go back more than 7 years on older stuff. Can you? Yeah, if you claim aggravated identity theft and we've got the QSIP and it's still being traded, you could go back against it. The IRS doesn't like to do more than 7 years. We usually say just let it go. But if you're actively in a case, yes, you can start this process at any time during the case. That's not a problem. If the case has already been adjudicated and is done, yes, you can go back and do the accounting and vacate the case, right? So you just have to like pick what's right for you and what you're willing to do and how hard you're willing to fight. Okay, but ultimately, in the end, they cannot lie about the accounting. You can file as a creditor on the accounting, and there's nothing they can do because you're doing the accounting properly, and they can't say no. As soon as they complain about the accounting, it's like, okay, well, let's talk about the accounting. Right? Isn't that ironic? If they want to complain about the accounting, let's talk about it. Fine. All right, let's open up jury. And so this is what happens in court when you start talking about the accounting. The judge will, in the types of motions we put in the court, the judge will actually call the bar attorney on the other side, whether it's a prosecutor or a private attorney in a civil case. He'll actually call the other side This is ex parte communication, by the way. This is actually highly illegal, violation of due process. They don't care. And the judge will say, don't say anything in my courtroom. You guys screwed up royally. You put my job on the line. I could go to prison because of you idiots bringing this case into my courtroom. I will do all the talking. And what you'll see is the attorneys on the other side will just introduce themselves, then they will say nothing. And the judge will only address you, or the judge will only address them, right? But they won't say anything. The judge is basically berating them, right? And then the judge may look at you and see if you agree. And then you just have to keep telling the judge, well, you know, I'm only here to revoke and revest the trust securities and do the accounting. I don't agree with anything that you're doing here today. I think this is criminal embezzlement and tax evasion. I think I should report you to the IRS. Bailiff, this is embezzlement. You're a first-hand witness. I think you should arrest the judge. Right? Oh, I've walked out of the courtroom before, and the bailiff was literally standing at the door in the jurisdiction where I was in. They don't stand in the pit. And he looked at me as I was walking out. He's just like, how many felonies did the judge just commit today? And I chuckled and I said, a lot. The bailiff literally knew, right? I'm just like, you should actually be arresting the judge right now. And I could just saw like deer caught in the headlights. He's just like, oh my God, I can't arrest the judge. I'd probably get fired. You know, that's what they're thinking. We're here to protect the judge. Right? They're not used to, you know, basically telling them to arrest the judge for embezzlement. Because the judge is your banker, the judge is your trustee, the judge is the accountant. At the end of every single case, the judge does an accounting and then orders somebody to pay and perform. That's their only job. These are courts of accounting, period. They laugh at people that argue case law. They just want the accounting. They want an agreement between the parties. You're going into that courtroom. I agree to everything that you say. I just need the accounting. Right? We're operating in honor. Right? Matthew 5:25-27. That's what they're using against us. Right? Or for us, if that matters, for that matter. But they are coveting our property. So, you know, they're breaking a whole bunch of biblical principles. But another story for another day. They will answer soon enough. They will answer. They're not allowed to put us in a bondage, and that's what they've done. It's not voluntary. They're hiding it. They're tricking us. It's all over the Bible. Just, you know, read Proverbs, you know, right? Read, you know, all over the Bible. It tells us what they're doing to us. Pay attention.
Wonderful. Okay, I have a question here that I think I understand it. It goes right to the very source of the origination of this problem for us as individuals. So the person states, I never created the certificate of live birth. The system created it.
No, your mom did. I have I'll give you the memorandum of law for that. Right? We've used this in court. They don't like it. This is true. So rather than to go into that, I'll just give you the memorandum so y'all can read it. It's just faster that way.
But it's true that the security is based on my likeness.
No, it's based on your future labor interest deposit. The birth certificate is a security. We get the CUSIPs for your birth certificate and we file liens against them all the time. It's pretty common for my clients that we do that as part of an estate conversion.
And it's my mother I can thank for that, you're saying.
Yeah, we can thank our moms. Thanks, Mom. You put us into slavery and bondage.
Oh, for our own good.
I'll get you sooner or later, Mom. You're busted. And that, by the way, also creates parens patriae and in loco parentis jurisdiction over your family and your children, by the way. That's how the state comes in with CPS and snags your children and hauls you into court and does all kinds of dumb stuff.
It makes perfect sense. Someone asks, are you familiar with the W-4 audit process, and is this a similar process?
We don't do a W-4 audit because that's not appropriate. We do the 1403 aggravated identity theft. Once you claim that, it opens everything up for audit under 26 USC 7201. Remember, we have to do what the IRS wants us to do, right? We can't do any like funky monkey forms that aren't necessarily designed to do that. Like the W-4 is not designed to audit. Now, are they using you as a corporate entity, an employee or some type of subsidiary of the court? Yes. But that's why we fill out the 1099-A and the C properly, and we show that the court is the the borrower, we're the lender, they're the debtor, we're the creditor. That's why we fixed it in the commercial realm, and we don't worry about the W-4. W-4 is a waste of time. The 3949-A is a waste of time. There's a Form 56, waste of time. They know they're trustees, right? Those are old tactics that were used a long time ago. They ignore those now.
And have you ever worked with anybody, or do you know anything about stopping a foreclosure with this method?
Yes, yes, we do foreclosure. This is called discharging debt under the Fair Debt Collection Practices Act. Clients that want to do discharge on foreclosure, defense, and cars, that's chattel paper, you are going to court, right? You can win in court, but you are going to court. And we do the similar thing than the traffic tickets we do against the bankers. There's a trust involved, and we go after the indentured trustee and we revoke and revest everything. We nail them for embezzlement and tax evasion. It's a similar process, just some different forms. There's a full administrative process that has to happen under the Fair Debt Collection Practices Act, 15 U.S.C. 1692G. We force them to validate the debt under UCC 9-210.
Yeah, I can see. I'm learning, and I can see it starts to apply universally, the same concept.
Congress did give us remedy. It's just really hard to get at it. And right now, I warn everybody with discharging mortgages or foreclosures and cars. The court or the banks are insolvent, and the courts are protecting them at all costs, including allowing them to violate statutory rules, even for securitization and the proper filing of standing at the recorder's office. They're letting them violate everything at this point, and they don't care because the banks are insolvent. They can't take any hits. They don't have the money.
Yes, you said that Friday, and I had a question about that. I'm like, if I was a bank and I have fractional reserve lending and I get the cheapest credit, I get the money at the cheapest rate possible.
They're making 400% compounded. How are they broke?
How can you how can you not
Think,
win?
think about how much money the executive teams are paying themselves.
Wow.
Yeah, where do you think that money's going? It's going into the executive teams and the board and the creditors, right? The actual investors in the bank, not the people that own stock, but the actual investors on like the A side, and the people that actually started and really own the bank, the foreign creditors, the foreign banks. Oh yeah, they're raping the Treasury Department as fast as they can, and they're slaving us with debt that can never be paid. That's why I laugh when they say, "Oh, we have $31 trillion in debt." That's the budget for Congress. That's not the actual debt. If you actually look at the IRS and find out how much actually debt, I'd laugh. I mean, I've tried to calculate it. I want to say it's in the nontillions.
How
That's a
many?
lot of zeros.
Is that after trillion?
Yeah. So trillion, right? Then what is it? Quadrillion, septillion, sestillion, septillion, octillion, nontillion.
Oh, non-trillion. Oh my
Well,
goodness.
think about that. We've been in debt since 1789 under the Paris Accord from the original bonds that created the supremacy clause with the Paris Accord, right? We never paid those creditors back, and so there's no proof that the Paris Accord was ever paid in full. So you can imagine 250 years of compounding interest to Great Britain and our foreign creditors, right? With the Rothschilds, funding most of the Civil War. Or not the Civil War, but the Revolutionary War. Well, they funded the Civil War too, but yeah. It's not possible to pay back what we owe. That's why they're trying to dump the debt into the cryptocurrencies and then devalue it and dump the debt onto the rest of the world.
Well, that's our time for tonight, and it's been an amazing gathering, amazing sharing of information. Thank you, Todd, for being here.
I basically loaded you up with decades of knowledge at this point, and I really pinpointed the only things you really need to know. Right? We're not arguing massive case law all over the place. It's simple forms and motions to the court to deal with the trust and the accounting. Outside of that, it's a moot point. It's arguing your brain to death, right? And the courts don't like that. The courts want you to do the accounting. That's it.
Yeah.
They want agreement. They want the accounting. They want to make sure both sides say they're not being damaged.
Yeah, I just keep learning stuff I didn't know. When the pandemic and the lockdowns and the mandates and everything hit, I realized I didn't know much about the law because, what is a mandate? And so I've spent the last 5 years just going deep into the law. And now I realize now I have to learn economics.
A little bit, yeah. If everybody would learn some basic accounting, debits and credits, who's a debtor, who's a creditor, that goes a long way to understand the basics in the commercial realm of what's going on and where's the money coming from. Since I've mentioned this a few times, I want everybody to read the minor and minor account. Okay, so minor and a minor account. If you understand that that's where your credit is extended from and that's where they're tapping all their money from, that goes a long way to understand that you're the creditor, they're the debtor, they can't loan any money, there isn't any money. And so, yeah, it's an extension of your unlimited credit. And so that actually is one of my doctoral theses is bonds are legal tender for set off and discharge under the CISG treaty and the Uniform Commercial Code. So yes, I very much understand how credit is created and the bonding and underwriting commercial securities are created for our commercial paper system. And it's all run through the UK, the CISG treaty, UNCITRAL, right? Bank of International Settlements, it's the IMF at this point under Basel III. So there is no money. It's book entry. And so it doesn't matter whether we have paper currency, it doesn't matter whether we have the digital currency that's coming. We've been conditioned to do digital currency with our debit cards and credit cards. That's all digital. There's no transaction of federal, actual paper currency or coins. So, but overall, the accounting can never, ever change. There's always a credit column, there's always a debit column, there's always a creditor, there's always a debtor. Okay, and don't necessarily be afraid of what's coming, but learn how to leverage the accounting. And then I think, Glenn, in our next session, maybe next week, we'll go over how we protect this position with the trust. Because that's a critical element to understanding how accounting works and the protection of assets through trusts.
Indeed. How do we amass wealth and protect it in our lifetimes? And then
Yeah. Generational wealth, actually,
pass it
not
on.
just our generational wealth creation.
Yeah, that was the big takeaway I got from that trust book you mentioned, is that this is not designed to be a hack or a trick to try to
No.
make some money. This is really an authentic desire to fulfill God's commandment to prosper and to
Yeah.
multiply.
Yeah. Yeah, it's not a trick. We're just using the system the way it was designed for us. The whole system is currently a trust. It's always been a trust. And when you understand that concept that you're not supposed to own anything, but you're supposed to control everything, you become judgment proof. You can lien things, nobody can take your property from you. You get very nice banking advantages from the banks. You get really nice help from the IRS for doing your taxes, right? It becomes a much cleaner, nicer, funner environment. We're no longer worried. We're no longer running around scared all the time or anxious and stuff like that because we're sitting back and we're just laughing at the idiots in public doing stupid stuff in the public while we're sitting back being private and everything's protected.
Wow,
Right?
those are some great final words. Thank you very much again for being here. Write us at info@commonerlaw.com if you have an interest potentially for personal service or to give us some feedback about how you'd like to apply this in your life as we're developing our curriculum.
I think we'll schedule another time to go next week, maybe for the trust. And I think everybody will enjoy that because it'll bring us down a notch on the anxiety level on the traffic ticket issue into, oh my gosh, I can protect my family very, very easily. And it's not that hard to do.
Yeah, look forward to much more from Todd. He's got a wealth of knowledge, but as you can see, you need to study this stuff, and we're going to do our best to craft together a curriculum that really serves you. Again, thanks for being here, Todd. Thanks for everyone for showing up.
Grateful for you guys.
God bless everyone.